Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to continue with the case of the Queen and Rana. Now, if you haven't watched the first part of this, I recommend that you do that because it'll provide you a much better understanding of what's going on. In that video, I covered sort of the underlying facts in some detail, as well as the charter issues. But if that's something you don't want to do, I'll go through and provide a really brief summary. So someone attended at Mr. Rana's house. They were let in by one of his family members. That person was quite upset. They blamed Mr. Rana for certain events in their own sort of personal life. They were angry. They were shouting. And so Mr. Rana called the police to have this person removed. The police took a long time to get there. So Mr. Rana made some follow-up phone calls in which he intimated that he might use a firearm, which he owned lawfully. He had a license. He had registration certificate and so forth. But he intimated to the dispatcher that he might use this firearm in self-defense, which got the police to come a little faster. But when they got there, their first concern was to secure this firearm. And in the process of so doing, they decided that it was not properly stored. That part of that is because Mr. Rana and Mrs. Rana testified that this was in a locked jewelry safe. However, the officer thought that they had just pulled it out from some clothing, so there was a dispute as to the facts on that one. Anyway, the court has found that it was stored in a jewelry safe. We'll have a look at this. But now the court has allowed all of the evidence to go in, and therefore is now going to apply the facts of this case to the law, and, vice versa, to see if they can convict Mr. Rana on the two counts that he's facing. The first is a careless storage of firearm, and the second is a storage of firearm contrary to the regulations. So there's two separate offenses. Let's dive in and see what's going on here. So part 3, the merits of the prosecution, and has the Crown proven the two offenses? Mr. Rana was charged with two but related offenses alleging careless storage of a firearm contrary to Section 86.1 and storage of the firearm in violation of the Firearms Act regulations contrary to Section 86.2. In these reasons, I will refer to the 86.1 offense as the careless storage offense and the 86.2 offense as the unlawful storage offense. As I will explain, the careless storage offense is a true criminal law offense, while the unlawful storage offense is more regulatory in nature. As I said in the first video, I really don't like this sort of distinction because Mr. Rana, if convicted on this, doesn't get a regulatory record. He gets a criminal record. He suffers the full consequences of having a criminal record, which can include, effects on his employment, effects on travel, all sorts of things. A criminal record can mess up your life in all sorts of ways. So pretending that this is not a criminal offense, that he's not being charged and facing a criminal offense, and this is something that shows up in many court decisions, but I would love to see this go up to the Supreme Court to examine this, because in my view, calling it sort of a regulatory offense kind of downplays the severity and also tends to be used as a shortcut where they say, oh, well, we don't have to follow the procedures for criminal charges because this one's sort of pseudo-regulatory, and I don't agree with that. Anyway, continuing on, I will first examine both offenses, juxtaposing their similarities and differences to highlight what the Crown must prove to secure a conviction. So he's going to go through these offenses and provide some explanation, which is helpful. So Section 86.1 of the Criminal Code provides every person commits an offense who, without lawful excuse, uses, carries, handles, ships, or transports, or stores a firearm, prohibited weapon, restricted weapon, prohibited device, or any ammunition, or prohibited ammunition, or prohibited ammunition. It looks like there's a bit of an error there because I just said prohibited ammunition twice, in a careless manner or without reasonable precautions for the safety of other persons. Mr. Rana was charged with the particularized offense of unlawfully storing a firearm, namely a handgun, in a careless manner. He was not charged with the careless use, carrying, handling, etc. Nor was the offense particularized to allege an offense based on failing to take reasonable precautions or safety of other persons. As the Supreme Court has held, it is a fundamental principle of criminal law that the offense, as particularized in the charge, must be proved. This seems to me to be a bit of the court kind of chiding the Crown, maybe for saying, maybe you should have charged this in other ways. Maybe you could have gone with, careless use, careless carrying, but I'm not really sure. at any rate, the judge is basically saying they have to prove what they actually alleged. And so they can't, for instance, because they said storing a firearm, they can't get a conviction for careless handling of the firearm in this particular circumstance. Usually the way the Crown gets around that is by alleging all of that. And so what you see is people who are charged with, careless use, storage, etc. And they're going, wait a minute, why am I being charged with careless shipping of this firearm? Anyway, that's just sort of something that comes up, and this is the kind of reason why. Section 86.2 of the Criminal Code provides every person commits an offense who contravenes a regulation made under paragraph 117H of the Firearms Act respecting the storage, handling, transportation, shipping, display, advertising, and mail order sales of firearms and restricted weapons. And that section just permits the governor and council to regulate those things. There's no dispute in this case that the 9mm handgun that was being stored in Mr. Rana's residence is indeed a restricted weapon. I kind of dispute this because restricted weapon and restricted firearm are different things. This is perhaps uncareful language. It's very common that people muddy these things up. But for instance, a prohibited firearm and a prohibited weapon are different categories. Restricted firearm and restricted weapon are different categories. So he means restricted firearm in this circumstance. Even without Mr. Rana's admission, this was proven by the evidence of McLean, who testified as much. The storage of restricted firearms is governed by Part 6 of the regulations. It provides an individual may store a restricted firearm only if A, it's unloaded, B, it's rendered inoperable by means of a secure locking device and stored in a container, receptacle, or room that is kept securely locked and that is constructed so that it cannot readily be broken open or into, or stored in a vault, safe, or room that has been specifically constructed or modified for the secure storage of restricted firearms and that is kept securely locked, and it is not readily accessible to ammunition unless the ammunition is stored together with or separately from the firearm in a container or receptacle that is kept securely locked and that is constructed so that it cannot readily be broken open or into, or a vault, safe, or room that has been specifically constructed or modified for the secure storage of restricted firearms and that is kept securely locked. In the Queen and Falauca, which I've got a couple of other videos on if you want to search those out and find them, the Supreme Court considered the regulations, albeit in a somewhat different context. That was a guy with a rifle sort of concealed on the SkyTrain, and said they are designed to protect people from the threat of violence that results from the public presence of firearms. Implicit in these comments is the recognition that the regulations are intended to provide minimum standards for the manner in which firearms are stored and transported. The offenses created by Section 86 of the Criminal Code prohibit an act or omission which constitutes the offense of careless storage of a firearm. In the Queen and Durham, the Ontario Court of Appeal upheld the constitutionality of the careless storage provision and said it is part of an overall regulatory scheme which imposes a duty upon all persons in possession of firearms to handle, store, and use their weapons carefully. This is consistent with the purpose of the regulations. Courts have recognized a distinction between the two offenses of careless storage in Section 86.1 and unlawful storage in Section 86.2. The unlawful storage offense requires the Crown to prove only that Mr. Rana contravened the relevant storage provisions of the regulation to the Firearms Act. Unlike the careless storage offense in Section 86.1, the unlawful storage offense does not include any element of reasonableness or carelessness in the manner in which the firearm is stored. We'll come back to this point later. Storage of the firearm contrary to the prescription of the relevant regulation makes out the offense under Section 86.2. In the Queen and Lieben, the British Columbia Court of Appeal held that guilt for an unlawful storage offense in 86.2 requires only that the offender fail to comply with the applicable regulation. Failure to advert to the safety risk of storing ammunition and firearms together is not a component of the mens rea of the offense. The legal manner of storage is prescribed by the regulation and not to be judged by the reasonable person standard of safety. In contrast, the careless storage offense under Section 86.1 requires the Crown to prove beyond a reasonable doubt that the conduct of Mr. Rana in storing his 9mm handgun constituted a marked departure from the standard of care expected of a reasonably prudent person under the circumstances. It is the conduct of Mr. Rana, and not, for example, Mrs. Rana, which is to be measured on an objective standard. The Supreme Court described Section 86.1 of the Criminal Code as involving a specific and rigorous duty of care. In Finley, the Supreme Court held, the objective test for negligence is discussed in Gossett, released this same day. In Gossett, I found that the proper interpretation of the fault element under Section 86.2 is conduct that constitutes a marked departure from the standard of care of a reasonably prudent person. If a reasonable doubt exists either that the conduct in question did not constitute a marked departure from that standard of care, or that reasonable precautions were taken to discharge the duty of care in the circumstances, a verdict of acquittal must follow. In Gossett, I found that the objective assessment of fault also had to consider the capacity of an accused to meet the standard of care required in the circumstances, and the accused's ability to control or compensate for his or her incapacities. There is, however, no reverse onus on an accused to establish, on the balance of probabilities, that he or she exercised due diligence in order to negate a finding of fault under Section 86.2. Further, the Supreme Court also indicated in Finley that even if a marked departure is established, Section 86.1 allows for the existence of a reasonable doubt as to either the sufficiency of the precautions taken by the accused to avoid the creation of risk, or the capacity of the accused to meet the standard of care of a reasonably prudent person in the circumstances. In summary, in order to obtain a conviction under Section 86.1 of the Criminal Code, the Crown must prove that Mr. Rana stored his handgun, even for a temporary nature, in a careless manner. A modified objective test applies. This requires proof of conduct that constitutes a marked departure from the standard of care of a reasonably prudent person in the circumstances. If a reasonable person in the position of the Mr. Rana, I'm not sure, there's a bit of clumsy language there, would not have been aware of the risk or would not have been able to avoid creating the danger, an acquittal will ensue. The decision in Blanchard encourages a two-step test to the determination of liability under Section 86.1, with the regulations serving not as an element of the offense, but setting the standard of care. What they mean is that prima facie, so before anything else is considered, the regulations are kind of your starting point for the standard of care. Further, courts have held that the two offenses are distinct offenses and can invite different verdicts. In other words, if the Crown fails to prove one offense, this does not foreclose a conviction on the other. Breaching the pertinent regulation, if proven, does not in and by itself constitute a violation of Section 86.1 of the Criminal Code, and they cite to Gore. The careless storage offense in Section 86.1 is broader in scope than the unlawful storage offense because it can be proven through carelessness, which is not an element in the unlawful storage offense. The provisions of the regulations are but one piece of evidence that may be considered in determining whether the careless storage offense has been proven. Finally, in Porter, which I've covered in another video, the British Columbia Court of Appeal considered the meaning of kept securely locked in the above regulation. At paragraph 28, the court agreed with the reasons of the trial judge, who found that the regulations were intended to set out, and did set out, a certain and clear method of storage by way of conventional locking, and that other methods of storage were simply non-compliant. If you haven't seen that video, Porter involved sort of a box that was nailed shut, and the court found that the regulations require a lock. And so, notwithstanding the fact that it's nailed shut, they said, that doesn't include a lock, so not good enough. I'll leave it to you to decide if you think that law makes sense, but that's the way the law works. So in view of the above principles, I will first examine the unlawful storage offense as a key piece of evidence that may or may not support the Crown's burden of proof in respect of the careless storage offense. All right, so now they're going to get into, it's listed as the positions of the parties here. And so what that means is, we'll have the Crown's argument and the defense's argument presented to us. And so I'm going to go through these and I'm going to have some comments on them. So Mr. Black argues that there are three pathways to liability in support of his submission to find Mr. Rana guilty of both offenses. In my view, the third pathway is really a submission about Mr. Rana's liability on the careless storage allegation. The first two pathways have more bearing on the unlawful storage offense. The three pathways were identified as follows, and I think the court is right about this. First, the pathway, and this is, Mr. Black's position, Mr. Black being the Crown prosecutor. The firearm was not stored in a safe. There was no trigger lock on the handgun. Further, storing the handgun in a closet is in violation of the regulation. So, as I mentioned earlier, the Crown's position was that the safe doesn't exist, that there is no safe, that this was made up by Mr. and Mrs. Rana as, a method to avoid liability. So pathway one is if the court agrees that there isn't a safe, then they should convict them. And frankly, I agree with that. If the court finds that there is no gun safe, then on the facts that we have here, I think they'd pretty much have to convict him on the unlawful storage. So that one is, I've got no concerns with point 1 here. Point 2, if the firearm was stored in a safe, the safe was a household safe for valuables, not constructed or modified for a restricted firearm. The safe is not kept securely locked. Either way, Mr. Rana was in violation of the regulation. So I'm not sure what the evidence is on the securely locked, because the only evidence that was given was that the safe is kept locked. This one, in my view, and the court ultimately sort of splits the baby on this one, but in my view, this notion that the safe being a household safe for valuables, I think it's a misreading of the legislation, and I'll sort of note why here. Scrolling back up, when it says stored in a vault, safe, or room that has been specifically constructed or modified for the secure storage of restricted firearms, several other cases have held that it's basically a vault or a safe or a room that has been kept or been specifically constructed or modified for the secure storage of restricted firearms. So that clause of specifically constructed or modified applies to room, but not to vault or safe. And when you think about that, that sort of seems to fit with what Parliament was likely intending here, because, let's say I knew some people who moved into a building that had once held a bank. And, there was a vault, but in that particular case, the vault door had been removed before they moved in, so it was just an unusual storage room. But let's say it hadn't. Let's say they bought this building and it still had an old bank vault in it. That seems to me to be good enough to store firearms in, notwithstanding the fact that it was designed for money. And in fact, many safes are sort of designed for multiple purposes. It might be marketed in one case as a gun safe, but a safe is a safe, right? I mean, if it takes however long for somebody to get through, does Parliament really care that it's marketed in a particular way? Or, because really the only sort of adaptation that you'd make for a safe for storing restricted or storing firearms as opposed to, storing anything else is maybe a difference in the shelving inside, maybe a difference in terms of, does it have, foam inserts so that you can lean your guns up without it getting scratched up on the inside. But these aren't safety features. They don't, the public isn't endangered if you store a firearm in a safe that doesn't have little foam inserts. So it's very difficult to see that. And as I said, there's some prior case law that has interpreted it in the other way. None of that appears to be before the court here. So I don't agree with this submission here, because this submission basically says you can only use something that is sort of specifically a gun safe. And frankly, I think that the case law goes the other way, but I'm not sure what's going on here. I don't know if there was case law presented to the court, but none seems to be cited here. The safe not being kept securely locked, I think, is still an invitation for the court to disbelieve Mr. Rana's evidence, although the court does something interesting with that we'll get to in a moment. So the third pathway is, regardless if there was a safe or not, Mr. Rana's conduct in storing his firearm, for which only he is licensed in a jewelry safe controlled by his spouse, amounts to a marked departure from the standard of care of a reasonably prudent person in the circumstances. So Mr. Rana's overall position is that the Crown hasn't proven either offense. First, he invites the court to accept the defense evidence that the firearm was stored in a locked jewelry safe and was not, as testified to by Clausen, removed from a pile of laundry in his bedroom. He alleges Clausen committed perjury by stating he was given the gun box by Mrs. Rana, which he says is contradicted by the defense evidence. Second, he urges the court to interpret the unlawful storage provision in a way to avoid an absurd result. He says the regulations permit a registered owner to have a restricted firearm in a box designed for its storage and remain unlocked provided the gun box is in a locked safe, as was the case here. Frankly, I agree. That seems to be the case law. That's the reading of this. But it says further, he says that the safe may be attended by anyone authorized by the licensed owner of the firearm, which was the case, which in this case was present because Mrs. Rana was authorized to use his firearm under his direct and immediate supervision in accordance with the Criminal Code Section 95 sub 3. I don't agree with that. That doesn't make sense to me, because she can attend it when, she's under his direct and immediate supervision. But the evidence here is that she had, control over it when she wasn't in his direct and immediate supervision. So that's a problem. Finally, he says the Crown didn't tender expert evidence from a firearms officer to interpret the storage regulations. This is not a bad argument, because there is a substantial amount of case law that says that the court should have some expert evidence to assist in determining what, the standard of care is and what would constitute a marked departure. Now, in practice, I find that those experts aren't usually terribly useful, so I kind of waffle on this one, but it's not a bad argument. I certainly would have made the same argument here, but so there's one argument here that I wouldn't go with. The other thing is that he alleges Clausen committed perjury. I think that's too heavy under the circumstances. You don't need to say Clausen is perjuring himself. What he needs to say is that Clausen is wrong. And the court is typically going to be very reluctant to find that a police officer is committing perjury. Because, they're reluctant to find any witnesses committing perjury unless it's really obvious, but especially a police officer, because a finding by the court that he was committing perjury basically ends his career. And the court's not likely to pull that trigger unless they've got some really strong evidence. Here, the most likely circumstance isn't that Clausen was committing perjury, it's that he just didn't see, that he didn't take note of certain things, that they're in this closet. Maybe he didn't have a good angle because he's outside the closet. He's got to see, past what they're doing. So I think that would have been the better argument, but I think the court gives Mr. Rana a fair bit of leeway. I think, quite frankly, if I, as a defense lawyer, had said, he was committing perjury under these circumstances, I would have got a yelling at. That's what I'd expect based on sort of what's in this case before. All right. So the Crown's burden of proof and credibility. The determination of how Mr. Rana's firearm was stored at the material time and the circumstances of its discovery requires the court to embark on a credibility evaluation. There's a conflict in some of the evidence based on the account of Mr. and Mrs. Rana, as well as the police, but namely Sergeant Clausen, who came into the possession of the firearm. I will review these principles below. So what the court is saying is that Mr. and Mrs. Rana have one story, Sergeant Clausen has another, and so the court has to evaluate how they believe these stories and how to sort of mesh the different sort of interpretations of this. The burden of proof rests on the Crown to prove the two offenses beyond a reasonable doubt. In the case of the Section 86(1) offense, there must be prima facie proof of the offense before the onus shifts to Mr. Rana to prove he had a lawful excuse. Mr. Rana didn't focus his submissions on having a lawful excuse to store the firearm in the manner he did, although he did say it was only removed by his spouse because he had told her to take it out of storage so he could use it in self-defense. The Section 86(2) offense does not statutorily provide for the shifting of the onus to the accused to prove a lawful excuse if there is prima facie proof that the regulation is not being followed. In other words, if the Crown proves Mr. Rana was contravening the regulation as prescribed, the offense is made out without resort to Mr. Rana having a lawful excuse, which still might be relevant to proof of his mens rea. In the Queen and Lifchus, the Supreme Court of Canada indicated that proof beyond a reasonable doubt does not involve proof to an absolute certainty. It is not proof beyond any doubt, nor is it an imaginary or frivolous doubt. In the Queen and Star, however, the court pointed out that the burden of proof placed upon the Crown lies much closer to absolute certainty than to a balance of probabilities. So they're talking about, the Crown's burden. How much proof, how much evidence do they have to have? Balance of probabilities, which is not the standard in a criminal trial, would be 50% plus something. So a little bit more than 50%. But the court has said, it's much higher than that. If we were to sort of pick a percentage number, somewhere like 90% to 95% is probably a good guess, although the court is always reluctant to sort of go into that kind of percentages on proof beyond a reasonable doubt. They instead prefer this sort of descriptive language as to what that means. So further, because Mr. Rana chose to testify, I must assess his evidence applying the reasonable doubt standard. The judgment of the Supreme Court in the Queen and WD sets out the approach in assessing a person's credibility by using a three-step analysis. Those steps are as follows. 1. Do I believe the evidence of Mr. Rana? Because if the court believes his evidence, then, in theory, if his evidence provides him with a defense, then they'd have to acquit. 2. If I do not accept his evidence, does Mr. Rana's evidence leave me with a reasonable doubt about his guilt? So this happens sometimes where the court says, listen, I don't buy your story. I think you're lying to me. However, your story, the Crown hasn't eliminated it. It's still possible. And so, I don't like your testimony. I don't believe you, but it still raises a reasonable doubt. So that happens. And this is an important step. A lot of the case law on credibility assessment basically comes down to the court misses this step. So there's a lot of case law on this particular issue, but I'll cover WD in a future case or a future video because it's a really important case. If the answer to the above is no, when I consider the totality of the evidence, has the Crown proven Mr. Rana's guilt beyond a reasonable doubt? Now, note here as well, point number 1 doesn't necessarily lead to an acquittal here because the court might still believe everything Mr. Rana says and still find, that his storage wasn't proper. I think that's actually what happens here, but we'll get to that a little down the road. I'm going to have some comments, but I want to give you guys the background before I do that. Summary of legal conclusions. After considering the evidence as a whole, I have concluded that the Crown has met their burden of proving that Mr. Rana's manner of storing his restricted firearm violated the provision in the regulations, specifically Section 6B2. I cannot rule the possibility of the firearm being stored in Mrs. Rana's jewelry safe prior to it being removed by her. I think there's a missing word there. He can't rule it out. So, there's reasonable doubt about it being in the jewelry safe. It says, however, this does not mean it was being stored in accordance with the regulation. I disagree with the interpretation of the regulation urged upon me by Mr. Rana. In my view, the regulation must be given a purposive meaning, and I agree with the Crown that the firearm was not being stored in a safe designed for its use. Even if I'm wrong about this conclusion, it certainly was not being stored securely in a locked setting as Mr. Rana divested control and storage of the firearm to his spouse. Mr. Rana made a conscious decision to store his firearm in this manner and meant for it to be stored in this manner, which was contrary to the regulation. Now, I take issue with this here because first, when he says, even if I'm wrong about this conclusion, in my view, the court is wrong about this conclusion because there is other case law that basically says that's not required for the safe element. So on that, I think he's wrong, but the court is hedging their bets a little bit here by saying, even if I'm wrong on this one, it's not being stored securely in a locked setting. Now, securely locked is a bit of a different phrasing than stored securely in a locked setting. It must be securely locked. And the evidence that was given in this says that it was locked in a jewelry safe. Securely locked and someone else has access to it, to my mind, seem to be different things. And there's actually going to be some case law that I think is very relevant and the court itself cites. So I'm going to just sort of put a pin in that and we'll come back to it. But that's a bit of an issue. There's also something where they say Mr. Rana made a conscious decision to store his firearm in this manner and meant for it to be stored in this manner. I think there's actually some question as to whether Mr. Rana was storing it in that manner, or whether Mrs. Rana was storing it there. However, if you're finding that that's improper storage, I think that Mr. Rana could be convicted as a party to that offense, that he was, sort of in agreement and, possibly directed it. But the court never sort of really embarks on that. And I think there is some interesting questions with respect to the fact that there's two people involved here. It doesn't look like Mrs. Rana was charged with anything, or at least not, they're not co-accused anyway. So I don't know. So that said, I disagree with the Crown that his conduct in knowing and intending for the firearm to be stored in violation of the regulation also means his conduct amounts to proof beyond a reasonable doubt of a marked departure from a standard of care of a reasonably prudent person in the circumstances. In summary, the conduct of a person in his shoes who chose to store a firearm in an unlocked gun box, but one that is stored in a locked jewelry safe, does not necessarily amount to a marked departure from the standard of care of a reasonably prudent person. It may be a departure, but the offense requires proof of a marked departure. Alternatively, I am not satisfied that the Crown has proven beyond a reasonable doubt that Mr. Rana took unreasonable precautions in failing to discharge his duty in the circumstances. Put simply, while Mr. Rana's manner of storage was in violation of the regulation, the following factors militate against proof of the careless storage offense beyond a reasonable doubt. So first, the firearm did not have a trigger lock, but was in a gun box designed for it. I mean, the gun box is probably a cardboard box that it originally came in because it says, Beretta on it. We heard that before. I'm not sure that I would have put a whole lot of weight in this, but the court considers it in any event. 2, the firearm was only accessed by Mrs. Rana when she tended to her jewelry. And 3, the firearm had no ammunition, thereby the risk created by careless storage was remote. And I think that one's actually a fairly strong point here. As for the Crown's additional submission that the firearm was carelessly stored by Mr. Rana when he became aware that Mrs. Rana stored it in her shawl with his knowledge, in my view, that is not enough conduct to ground criminal liability for a true criminal law offense, which attracts high moral stigma. The gravamen of the Section 86(1) offense is the historical storage of the firearm. In any event, I have reasonable doubt that a person in Mr. Rana's shoes ought to have known that Mrs. Rana would, despite his instructions to the contrary, not return the firearm to the locked safe where it would be unlawfully stored, but not carelessly stored. Either way, the Crown has not proven this count. I'm also not sure that that can properly be counted as storage. She's got this thing, she's carrying it around, she's doing things with it. That doesn't seem like storage to me. That's use, handling, etc. Those are different categories, and those categories are exclusive. So it's not that she's storing it in her shawl, she's handling it, she's using it. So, it's one of those. So I don't think that that's properly something that can be characterized as storage. So if I was the judge, I would have rejected that argument simply because she's not storing it under her shawl. She's something else. That's not a storage situation. The judge now moves on to findings and discussion. I now turn my findings in support of the above legal conclusions. So these are going to be the factual findings of the court, and those, as I think I've noted previously, are very difficult to overturn on appeal. You're almost always stuck with the facts as the court finds them. So let's continue on. For the most part, there isn't much conflict in the facts, except for a divide in the evidence of Sergeant Clausen and Mr. and Mrs. Rana about the circumstances of discovering the firearm. Sergeant Clausen testified he never saw the gun box being removed from a safe and instead saw it produced from a pile of laundry in the walk-in closet. He also says Mrs. Rana produced the gun box directly to him, which is contrary to the defense evidence that the gun box was given by Mrs. Rana to Mr. Rana, who then turned it over to the police. Overall, I found Mr. Rana to be an articulate and thoughtful witness. He was not evasive. I agree with the Crown that he was not completely forthright with the 911 operator and was prepared to mislead them as to the urgency of the call in order to gain an advantage. But I've been careful in not using this evidence to support propensity-type reasoning that just because he would mislead the 911 operator, he would also mislead the court. Context is important. There's no doubt that Mr. Rana was very careless in the language he used when he called 911, but it was done with the intent of having the police arrive quickly because he was desperate to have the intruder removed. His conduct on the call was foolish and may even constitute legal mischief, but he was also clear he was a registered firearm owner and wouldn't use his firearm. He wasn't hiding he had a firearm. I have to test the substance of his evidence. Foolish is a fair way to describe it. Calling the police and saying, I've got a gun and it's not going to be helpful. I also don't hold his initial reluctant position with the police against him because in his mind, he didn't think the police were there to investigate a gun call. They were there to investigate a trespass call. Again, this was a foolish thought in light of what he said, but his equivocation when first asked about the gun doesn't detract from his credibility, especially because he was more than forthright in helping the police find the gun later. Mr. Black says both Mr. and Mrs. Rana are not credible on the safe issue, and it's a ruse designed to mislead the court, and the court should prefer the evidence of Sergeant Clausen, who said he watched Mrs. Rana search for the gun box and found it in a pile of laundry. After considering the evidence as a whole on this issue, I have a reasonable doubt and find that there was a black household safe in the closet. I say this for the following reasons. So again, Crown Prosecutor here is saying that the safe doesn't exist, that Mr. and Mrs. Rana are lying about it, and if that was what the court had found, then the conviction would have flowed pretty much automatically. They'd be in a very tough spot here. I don't see that they'd have a defense to the unlawful storage aspect. To the careless, yes, but to the unlawful storage, I couldn't see it. So, first, Mr. Rana's evidence that he purchased the 9mm Beretta gun as a legacy piece must be viewed in context of his prior training in the armed forces. There's also no dispute that he's a registered firearm owner. It was obvious that the firearm holds value to him, and it's not unreasonable that he would know its storage would require a vessel to preserve its value. He said he bought the safe at the time he acquired the firearm. This evidence was supported by Mrs. Rana, who knew about the safe. While there was most certainly an opportunity to collude, I'm not prepared to find that there was, in fact, collusion. She was not shaken on her evidence that her husband bought a safe and kept the firearm in the safe, and she had access to the key because her jewelry was also in it. Quite frankly, it was open to the police to obtain a statement from Mrs. Rana to preserve her evidence because she was clearly a witness to the careless storage allegation. The police chose not to do so, and complaining there's possible taint and collusion after the fact is, with respect, not tenable on this record. So the Crown is saying basically that Mr. and Mrs. Rana worked together and figured out what their story was going into court. And the court isn't willing to agree with that. They say, that doesn't seem to be the case here. And, if the Crown really was worried about that, they really could have gotten a statement from her ahead of time, and they didn't do that. There's also some discussion about this gun as, an item of particular value. I think that the Crown possibly could have brought in an expert as to the value of this gun, because I suspect it's not actually as much of a collector piece. But again, I don't know. I mean, this could be a rare and valuable one. But if this is just sort of an off-the-shelf gun, then this notion that it's this expensive collectible might have been an avenue to attack him on credibility. But bringing in experts is expensive, so I can see why they might not have done so. Second, Mrs. Rana came across to me as an unsophisticated witness. She testified with an Urdu and Punjabi interpreter, and she was skillfully cross-examined by the Crown. Her unsophistication was clear in her demeanor, suggesting she had nothing to hide and was telling it like it is. There is some friction between herself and Mr. Rana caused by private issues which aren't necessary to explore in these reasons, but she had very little motive to lie to support his position. So we can hear that there's some marital conflict here, and the judge is actually using that to bolster her credibility, because the judge is saying, listen, she doesn't like him all that much, and so she's got no reason to lie because she's already annoyed at him. Marital conflict is a fairly common result of criminal charges. That tends to be something that causes some marital strife. So I don't know if that's what was going on or if it was something else, but regardless. In the end, I don't think she had the capacity to cobble a sophisticated ruse about there being a safe. She was challenged on the physical aspects of the safe, including how it opened and closed. She withstood those questions with credible answers. So this is a fairly common tactic where you have multiple people testifying, is that you can start to get into details. And the reason why you do that is because then you can point out that the different people have different testimony about those details, and thereby suggest that they're making it up, that it didn't happen. The old joke that sort of goes with this is, four guys have an exam and they decide that they're going to blow it off, and instead they go fishing. So instead of having the exam, they're out fishing, and then they figure they're going to write a makeup exam. They can find out about the exam from their colleagues, and they'll have a tremendous advantage. And collectively, they go in and they tell the prof, listen, we were all out together. We had a flat tire. We couldn't make it. That's why we're all late. We need to have a makeup exam. And so the prof says, okay, sure. I'll schedule a makeup exam for you guys. It's this time. And they're thinking, we're ahead of the game. We're golden. And so then they come into the makeup exam. They've studied. They've had extra time to study. They've got some hints from their colleagues. They're ready to go. And each of them gets parked into a separate room and, with their little sheet of paper. And each of them finds they have an exam with one question worth 100%. And the question is, which tire was the flat tire? Unless they thought about that, unless they planned that out, they've got some serious problems at this point, because if they start coming up with different answers, it's going to be a difficult situation. So that's sort of an example of, that's why the Crown prosecutor is asking her all of these details about the safe. But the thing that makes me wonder here is, if I was counsel for Mr. Rana, I would have said, bring the safe in. Like, we're going to make that safe an exhibit. We're going to show the court, here's the safe. Because it's a lot more credible to say, here is the safe, if you actually bring it to court and you can show it to people. Even just, here are pictures of the safe would be a big advantage. But that doesn't appear to have happened. Anyway, or at least there's no indication of it. And it would have been very difficult for the Crown to start asking her about, how it opens and closes if it's not there. Although it's possible that it was there and they were just seeing if she'd ever actually used it. It's hard to say. It's not entirely clear on this one. Where I was left troubled by her account is the illogic of her actions on the date in question. She was asked why she removed the firearm from a safe when she had the key, and said she was worried her husband might access it and create a volatile situation with Mr. Qureshi. It was put to her that if that was her purpose, it would make more sense to keep the key and prevent her husband access. Clearly that is sensible, but she testified things happened quickly, she panicked, and thereafter the police arrived before she could correct her mistake of taking the firearm and hiding it. I am satisfied she hid a firearm under her clothing to prevent her husband from accessing it. The shawl evidence was not concocted and is on the surface somewhat bizarre, giving it the ring of truth. This supports my finding that she did panic, she was confused, and she was not thinking straight. After all, she hid a firearm, which is a criminal offense of carrying a concealed weapon. Note, carrying, not storage. Different things. Logic dictates most people try not to commit criminal offenses. I mean, most people, that is true. Some people, criminal offenses are kind of their day-to-day activities. So she wasn't going to use the firearm, but instead was trying to prevent her husband from using it. I accept her evidence that Mr. Rana asked her to remove the firearm from the safe, and she said no, then poorly took matters into her own hands. So the judge here is sort of saying, her story is weird, which means it's probably true. And, one thing that sort of often happens is people make up stories in court, and their stories are often sort of too perfect. But, the truth is often ugly. It's often people do stupid things, they screw up. And, if you're coming into court to tell a story that is, a concocted one, telling a story that sort of involves you screwing up isn't sort of the usual thing. So that's part of the judge's credibility findings here. Third, the Crown says that the Ranas are inconsistent about the exact location of the safe in the closet. Mr. Rana said it was in the back of the closet, and Mrs. Rana said it was in the center. I don't view this as a material inconsistency. The important point is whether a safe existed at the time. I simply can't rule this out on the record. Fourth, Sergeant Clausen testified he saw Mrs. Rana remove the gun box from a pile of laundry and not from a safe. I agree with the Crown that his evidence was straightforward, but this doesn't impugn the position of Mr. Rana. I found that Sergeant Clausen never went into the walk-in closet, where he would have been able to take inventory of all of the items in the closet. The evidence is clear there was clothing in the closet, and Mrs. Rana said she removed the firearm from the safe and the gun box, and only took the gun with her. This means she would have left the gun box behind, and when summoned upstairs, returned the firearm in the gun box where she found it. The evidence unfolded quickly, and nobody saw fit to ask about a safe because it wasn't on anybody's mind. I agree with the Crown that Sergeant Clausen was credible, but there is a gap in the evidence with respect to the safe because he never searched inside the closet. I'm also mindful that the scene was chaotic, and there were some language barriers with Mrs. Rana. So that's telling us here, this is sort of what I was saying about the perjury versus confusion thing. The judge is saying, yes, I'm accepting Mr. and Mrs. Rana's, version of events. Sergeant Clausen couldn't have really seen all of this. It would have been hard for him to see it. These are sort of common mistakes people can make. So he's not finding Sergeant Clausen is lying, just that he's wrong. There's a big difference between that. Quite often you can have witnesses who are honest, like they're trying to tell the truth, but they're mistaken. They just don't understand what they're seeing, what they're looking at. So fifth, there was no legal obligation on Mr. Rana to speak up about a safe at the time of his detention or arrest. In the Queen and Lever, the Court of Appeal held that evidence of an accused's reaction to allegations is of limited probative value because it rests on assumptions about how a normal person would react. Mr. Rana was placed on notice he would be charged with unsafe storage based on the circumstances of an unlocked gun box in which the firearm did not have a trigger lock. That was the comment intimated to him by Sergeant Clausen. A safe was never on anybody's radar. Also, Mr. Rana has the right to remain silent, so saying that he didn't provide a story at the time of his detention or arrest kind of seems to be an attack on that, but the court doesn't sort of look in that direction. While the safe evidence is somewhat bizarre viewed in the context of this case, I have a reasonable doubt and find one existed, which was housing the firearm prior to its removal from Mrs. Rana. Turning next to the circumstances of the storage, Mr. Rana testified he was the sole registrant of a firearm in his house. He bought a safe and knew the firearm didn't have a trigger lock because the gun box was designed for the firearm to not have a trigger lock. Again, this is really common because most firearms are sort of manufactured elsewhere, but typically for the U.S. market. And so they're not sort of built for a trigger lock inside the box. This makes sense because the gun box would not close with a trigger lock. The photographs bear this out. However, he knew the gun box didn't have a lock because he couldn't find a lock for the gun box and thought about it and was satisfied it was safe because in his mind, it would be stored in a locked safe. He knew handguns were inherently dangerous and confirmed in unambiguous language only his wife had a key to the safe and he had no control over it. As he put it, I can't have control to open the safe. The clear implication of this evidence is Mrs. Rana had full reign of access to the safe, and as the evidence establishes, the means to withhold his access when she refused to retrieve the firearm at his request. So, here they're saying it's stored in a locked safe, and they previously described this as a metal safe. That seems to meet the standard in, for instance, the Queen and Barnes, which has been followed in a number of other decisions. So I have some concerns here because they don't mention, Barnes at all, which was the sort of leading case. And, there's no reason to distinguish it from Barnes. There's no reason why they're saying Barnes is bad law. So I'm wondering if Barnes was considered by the court. That is something that I think the court should have considered, and perhaps this might be a viable avenue for appeal here. With respect to the discovery of the firearm, I find Mr. Rana initially looked for the firearm in the walk-in closet, and Sergeant Clausen remained at the threshold of the closet but didn't enter to search inside the closet. Further, Sergeant Clausen could not recall with precision about how he received the gun box. In cross-examination, he acknowledged he wasn't entirely sure if it was given directly to him by Mrs. Rana, or if it was given to Mr. Rana, who later turned it over to him. On the whole of the evidence, it is sensible that Mrs. Rana turned it over to her husband, who had summoned her and was in the closet with her. However, this does not mean, as Mr. Rana asserts, Sergeant Clausen committed perjury. I'm entitled to accept some, all, or none of the evidence, and simply didn't find his evidence on this discrete point to be reliable. It does not mean he also wasn't credible. Reliability deals with a witness's ability to recall, recollect, and observe. It does not address honesty of a witness. I found both Clausen and Birmingham, whose evidence was challenged in this case, to be honest witnesses who had an imperfect memory of the chaotic events, and for good reason. So once again, the court does not go with the perjury thing, but they do find that there are some problems with their evidence. So this is a very common sort of thing. Often you don't want to accuse a witness of lying unless you've got something to suggest why they might do so. Often mistaken is a better angle, but that depends on circumstances. Things get complicated when you're in the sort of thick of a trial. With the above findings in mind, I will now explain why the Crown has proven the unlawful storage count. In doing so, I will address some arguments raised by Mr. Rana. First, there is no dispute that only Mr. Rana was registered to store the firearm. There is no evidence before me that Mrs. Rana was also registered to store it, or that a condition existed on his license permitting her to store it. Mr. Rana says the safe may be attended to by anyone authorized by the licensed owner of the firearm. I disagree with this argument. For starters, this defeats the purpose of the licensing regime, which authorizes a specific person to store the firearm as that person would have passed the licensing requirements to do so. The CFRO, and again, they are saying CFRO when they mean his possession and acquisition license. So they're misusing the terminology here. Didn't give permission to Mrs. Rana to store the firearm. Mr. Rana says if this were not the case, it would result in an absurd result because if firearms are stored in a business for trade or sport, everybody would need a license to access the firearm. This argument is without merit because the Firearms Act has a separate licensing regime for businesses. Different considerations apply to businesses than individuals who are given permission to store handguns. I agree that the business argument is not a good argument. This one is off base. However, the court seems to be saying that the registration creates the requirement that he store it, and that's not really the law here. it's, I mean, first of all, with respect to non-restricted firearms, those can be lent out very easily. They can be given away to other PAL holders. I'm not sure why they're saying, that he's the one who stored it because he's the one who's got the license. You can actually have a situation where she might have stored it. For instance, let's consider that he leaves his gun out and, just on the kitchen table. And she's unhappy with that. And so she moves it and instead decides to store it in a drawer, sort of somewhere in the house. And what you can end up with is a situation where he might be guilty of unlawful storage for having left it on the table, but she can also be guilty of unlawful storage for having, then moved it and stored it somewhere else. It's not this sort of conflation here of the licensing with who stored it. I don't agree that's the law. The law doesn't say that you are the person who stored it because you are the person who has the license. So, second, Mr. Rana says his spouse was fully authorized by Mr. Rana to use his firearm under his direct and immediate supervision. The problem with this submission is twofold. First, the license did not authorize Mrs. Rana to use his firearm under his supervision because only he had authorization to store it. Well, the license doesn't authorize her to use it under his supervision. That's actually the criminal code that allows that. So, again, this doesn't really fit. It looks like there's some gap in understanding here that's concerning. And I think that all of this is stuff that would be complicated to explore on appeal, but you'd certainly want to unpack it all as to where the court seems to be misunderstanding the legislative scheme, because there does seem to be some substantial misunderstanding here. And second, it flies in the face of his evidence that he relinquished control over the firearm to his spouse. He didn't even have a key. Only Mrs. Rana could have possession of the firearm and could do so without his consent, which is what she did on the night in question. Now, this sounds like reasoning about careless storage, not reasoning about the actual regulations, because the regulations don't say only the person who is licensed can store it. That's, only the person who is licensed can have possession of it, but that's a different offense entirely. That's, possession without a license. Had they charged Mrs. Rana with possession of the firearm without a license, I think they'd have a really good case here. But that's not the charge before the court, and the court seems to be kind of mixing different charges all together into one sort of weird legal soup. So third, Mr. Rana says the Crown is being stubbornly unreasonable with proceeding with the prosecution for this offense. This is not an argument that's going to go anywhere, but I disagree. Mr. Rana divested his duty to store his firearm to his spouse. He didn't bother checking on the status of the storage for years. Again, these are carelessness issues, not issues with respect to the regulations. Mr. Rana says possession implies control over the firearm, and he was in possession of it. I note that the regulations don't speak to how often you have to check on the firearm at all. In my view, Mr. Rana was only in possession by title and registration, but was clearly not in control over the contents of his wife's safe. And if he's not in control, how can he be convicted on the storage issue? That's a problem to my mind in the reasoning here. He drew an analogy in support of his absurdity argument, stating if he parked his car in the driveway of his residence, whose title belongs to his spouse, it does not mean he has bequeathed his vehicle to his spouse. I don't find this analogy persuasive because it misses the point in this case. Staying with the driving analogy, driving a car is a regulated activity. It is a privilege, not a right. A person has to acquire a driver's license to have the lawful privilege to drive. A person who does not have a license to drive cannot drive a car even if they own one. If Mr. Rana, as a licensed driver, chose to store his car in his garage that he jointly owned with his spouse, Mrs. Rana would not be permitted by law to move the car from the garage, irrespective of who owned it. Put simply, the regulation did not permit him to bequeath his obligation to safely store the firearm to his spouse. But if you look at this, like if Mrs. Rana didn't have a license and she gets into the car and she moves it, Mr. Rana, it's unless there's some joint thing, you can't sort of draw that connection. It's not oh, well, it's in your name. So, I mean, there is owner-operator tickets, but those don't apply to criminal law. This is very, the reasoning here I'm finding very hard to follow. It seems like a lot of different legal issues are getting muddled together. So fourth, while Mr. Rana stored the firearm in a gun box within a locked safe, I disagree with him that a safe need not be securely locked when it's being attended to. The purpose of the regulation is to prescribe minimum standards for licensed gun owners and to promote safety so guns don't get in the hands of the wrong people. The licensing regime expects gun owners to follow the regulations to promote safety. Here, Mr. Rana chose to store an unlocked gun box, albeit with no ammunition, in a locked safe. He admitted he had no control over the safe because his wife had the key. There's evidence the safe was being used for jewelry, not just the firearm, which means it was being accessed for other reasons apart from storing the firearm. This would entail Mrs. Rana going into the safe with a key, not a keypad, for example. It would be open when she obtained her jewelry, and the obligation would fall on her shoulders to lock it, not Mr. Rana, the licensed owner. He had no idea when his wife was going in or out of the safe. In this way, it was not kept securely locked. Except the only person taking it out of that securely locked stage is Mrs. Rana, so it's still securely locked, except if she's, opening it. That's, they're saying it was not in a vault or a special room with sole access by the registered owner. I don't see sole access being something that's actually listed in the regulations. The sole access issue is actually one of a possession issue. Somebody else who has access becomes in possession of the firearm unlawfully. There might actually be even a weapons trafficking argument, but, that's not part of the regulations. Continuing on, it is entirely conceivable that a household safe could be stolen during a break and enter. Again, this is not part of the regulations. The regulations don't say that. They say it's got to be in a securely locked, thing. But the fact that that thing is portable is in fact kind of specifically contemplated by the regulations at various points. Because, for instance, a securely locked containers usually aren't screwed down or anything like that. So again, this seems to me to be a carelessness issue that is being imported into the regulations and shouldn't be. So I have concerns with this judgment here. Mr. Rana could only hope his spouse would keep it securely locked. Simply put, that does not meet the minimum standard required by the regulation. It may not be the most egregious violation of the regulation, but that's a consideration for the Section 86(1) offense. However, the judge seems inclined with that statement to convict based on the possibility that she will leave it unlocked. But the regulations don't require that it be impossible. They require that they be followed, and the Crown has to prove that they weren't. This notion of could only hope his spouse would keep it securely locked, in my view, A, it's importing things into the regulations that aren't there, and B, it's actually reversing the burden of proof because now Mr. Rana has to prove that it would be kept securely locked by his spouse. So I don't think this reasoning is likely to stand up to a well-argued appeal. Proof of violating the regulation does not require the Crown to prove Mr. Rana was unreasonable or careless, only he didn't follow the prescribed regulation. Mr. Rana made a conscious decision to store his firearm in this manner and intended for it to be stored this way. I find the Crown has proven this count beyond a reasonable doubt. I disagree. If I was the judge based on these findings here, I would say it was stored in a locked safe. There is no evidence of it having been, left unlocked in any sort of unattended state. And therefore, you can't convict. I suppose the argument could be made that it's, that you could convict based on one of the times when she opened up the gun safe, except I suspect that the charge was particularized to on or about a particular day, and I couldn't see the Crown possibly proving that it happened on or about that particular day when the last time she went into her, into that safe. So I have some serious concerns with the validity of this reasoning and its ability to stand up to a well-argued appeal. Turning next to the careless storage offense, the Crown invited a conviction on this count largely for reasons that I've enunciated above. In other words, the Crown says once it has been proven the storage of the firearm was in violation of the regulation, a conviction for the careless storage offense follows because of similar reasons. Respectfully, I disagree. Also, respectfully, I disagree on this one as well. Me and the judge are, ad idem on this. There is tons of case law to say that, these two counts have to be considered separately. So first, as Justice Stone made it clear in Gore, if there is proof the accused has violated the regulation, it does not necessarily follow that there is proof of carelessness. As stated above, the gravamen of the offense is the historic storage of the firearm. Even if I am wrong about that and have to judge storage at the time it was investigated by the police, I don't think the evidence goes that far in proving guilt on either theory. I'd really want to know what day this was particularized to, or if it was particularized to a range of time, because the historic storage of the firearm might not have actually been before the court properly. That's something I can't comment on for sure, but certainly interesting. He would have also been in violation for its temporary storage without lawful excuse, but all this means is he was in violation of the standard of care required of a reasonably prudent person in respect of how the firearm should be stored. But does this mean his conduct in allowing this to occur was a marked departure from the standard of care? The regulation assists in framing this standard of care about how a reasonable person should behave in storing the firearm. There is no doubt his decision as to how to store the firearm departed from the standard of care required of him and a reasonable person, but the pertinent legal question is whether it was a marked departure or whether reasonable precautions were taken to discharge the duty of care. Again, the burden of proof rests with the Crown to prove both the actus reus and mens rea, so guilty act and guilty mind, beyond a reasonable doubt. This is a heavy burden. Courts have been clear that if a reasonable doubt exists, either with respect to Mr. Rana's conduct was a marked departure or whether reasonable precautions were taken to discharge the duty in the circumstances, then guilt cannot be found. The onus is on the Crown to establish beyond a reasonable doubt that the manner of storage gave rise to the potential for danger, and that's the Queen and Lulic. To determine if Mr. Rana's conduct amounted to a marked departure from the standard of care of a reasonably prudent person in the circumstances, I must analyze the location of the firearm, the location of the ammunition, if any, the surrounding environment, the manner in which he dealt with the firearm and ammunition in terms of their physical status, and the reasonably foreseeable presence of other persons, both children and adults. Queen and Lamoureux. The presence of children has been given significant weight in establishing risk throughout case law. And this is correct, because if you have kids, they tend to get into things that maybe they shouldn't, and they may not always make the best decisions. So kids being able to gain access to a firearm is typically one of those things that really pushes hard towards careless storage of a firearm. When considering my findings in context of the evidence as a whole, I conclude the Crown has not met their heavy burden. I have a doubt on both questions. I say this for the following reasons. First, the firearm was being historically stored in a designated gun box in a locked safe. While this was a poor choice, perhaps motivated by ignorance, it was in violation of the regulation. This is one factor in the analysis. It does not overwhelm the analysis. Again, I think the judge is wrong on the regulation aspect, but assuming he's right, we'll go through this. Second, there is no evidence that the firearm had any ammunition, let alone readily accessible ammunition, in the closet or home. Again, that's a big deal because if there's ammunition that could easily be loaded into the gun, then they tend to be more inclined to find that there's an issue there. Third, the firearm was being stored in a safe in the bedroom, out of view of his family members. Indeed, I accept that his kids didn't even know he had a firearm in the house. So they're going to be less tempted to look for it, less tempted to play with it if they don't know it exists. Fourth, it does not appear the firearm saw the light of day often, except when it would be handled by Mrs. Rana when she tended to her jewelry. In other words, there's no evidence to suggest Mr. Rana paraded it in the house or permitted his children to handle it, where the risk of returning it to the safe where Mrs. Rana may have forgotten to lock it was remote. Again, this may have forgotten to lock it is, this seems like pure conjecture that she may have forgotten to lock the safe. I didn't see anything in the evidence about how she sometimes forgets to lock the safe. So that's, when you think about it, everyone who has a gun safe, it's possible that you could forget to lock it. But, like my gun safe, I'm diligent about keeping it locked. But it's still always possible that it could be forgotten to lock. If the notion that it's not securely locked because it's possible somebody could forget, who can meet that standard? I don't think this logic works very well. So fifth, Mrs. Rana had control over the key. Thus, even if there was a risk that Mr. Rana, in a fit of anger, wanted to use the firearm, he would have to go through her as well. This tempers the risk to public safety as well. What if she gets angry? I don't know. Six, when Mr. Rana's conduct is measured against the cases in Canada, it offers support for my conclusion that Mr. Rana's conduct was not a marked departure, or that his conduct amounted to taking unreasonable precautions to mitigate risk. In Boutillier, from the Newfoundland and Labrador Supreme Court, they determined that the temporary storage of a handgun under the seat of a car with no ammunition in the near vicinity was not a marked departure from the standard of care of a reasonable person, because the unloaded gun was incapable of causing damage to anyone. The court noted that had the accused been charged under Section 86.2, guilt would have been established, which of course is the result in the case. In Lulick, the court held at paragraph 6, carelessness has been defined as doing or failing to do that which results or might reasonably be expected to result in some danger to others by reason of the inherently dangerous characteristics of firearms and ammunition. So defined, it can be seen that careless has essentially the same meanings as the phrase in the latter part of the section, without reasonable precautions for the safety of other persons, though the two are disjunctive. The court in Lulick proceeded to consider the relationship between the regulations and the objective test under Section 86.1 at paragraphs 9 to 10. And this one is, there's going to be something really tasty in this paragraph, so hopefully you're paying attention here. However, while the regulation sets the standard of care, the test under subsection 1 is a marked departure from that standard of care. Failure to comply with the regulation, while a departure from prudence, is not necessarily a marked departure. The Crown argues that where, as here, the defendant has failed to comply with 3 of the 4 requirements under the regulation, it must be considered a marked departure. I cannot agree. It is possible to imagine a situation where none of the requirements of the regulation were met, say a loaded firearm kept in a hermit's remote cabin, where no danger was created by that manner of storage. Conversely, it is possible to imagine compliance with all of the requirements of the regulation while still being careless within the meaning of subsection 1, say by doing what the regulation requires, but then leaving the required keys with a 10-year-old boy. I'm just sort of stopping here because Lulick, which is cited in this decision, notes that locking a firearm into a safe and then leaving the keys with an unlicensed person, in this case they're using the example of a 10-year-old boy, but Mrs. Rana fits in just as well, is compliance with all of the requirements of the regulation, but careless. I don't see how, it seems to me that the court, when citing Lulick, should have stopped and said, we're actually in the 4 corners of this bit that we're actually specifically citing. We're actually inside that zone. And so they should maybe have said, okay, the regulations were followed. Is this careless? And that's, I think, the better analysis here. This quoted paragraph seems to very much undermine and destroy the reasoning that they used to get to the conclusion that the requirements were violated. So I'm not really sure what's going on here. But again, this is the sort of thing I would love to explore on an appeal because, they quote this bit, and I don't understand how the other thing isn't exactly in this situation. Anyway, in my view, under subsection 1, the court must assess the danger or risk created by the manner of storage and determine whether in all the circumstances there has been a marked departure from the standard of care of a reasonable person. It is a fundamentally different and separate issue from that of regulatory compliance. The court in Lulick ultimately concluded that the conduct of the accused in storing his gun did not amount to a marked departure from the standard of care of a reasonably prudent person in the circumstances. In this case, Mr. Rana was in non-compliance with 1 and possibly 2 aspects of the regulation by allowing it to be stored in a household safe which wasn't kept securely locked. There was no ammunition. In my view, and largely for similar reasons in Lulick, a full consideration of all the evidence leads me to conclude that the Crown has not met its very high burden in proving this offense. Like Mr. Lulick, Mr. Rana effectively gave the key to storing his firearm to his spouse, but this very poor and unlawful choice cannot be equated with a marked departure to prove carelessness. But again, they're not really following the Lulick decision here. Anyway, The next issue that comes up is, should the proceedings be stayed? Mr. Rana was asking for a stay of proceedings, which essentially just kills the prosecution. It ends it with a stay, which is as good as an acquittal for Mr. Rana. If you reviewed the charter aspects, you'll note that the previous video, the court found that the charter issues were sort of at the technical and very minor aspects of things, so he's not getting his stay. Conclusion. In view of the failed charter applications, the evidence of the firearm is admissible. For reasons stated, Mr. Rana will be found guilty of the quasi-criminal regulatory offense of unlawful storage of his firearm under Section 86.2 and not guilty of the criminal offense of careless storage of his firearm under Section 86.1. Again, both of these are criminal offenses. I don't see how it can be called quasi-criminal or regulatory. Quasi-criminal is often used for things like traffic tickets, which don't get you a criminal record. But this, Mr. Rana is clearly going to get a record unless he gets a conditional or absolute discharge here. So calling it simply regulatory, in my view, kind of misses the mark. This result may not be the medicine for the sour taste left in the mouth of Mr. Rana, who called 911 for assistance, but the evidence establishes he made a poor choice in unlawfully storing his firearm. You bet it's not going to be medicine for the sour taste. I mean, Mr. Rana is... I can't see he's going to be happy with this result, and this certainly wasn't what he was hoping for when he calls 911 to get somebody out who, at the time, he believed was threatening his family. So, yeah. Even if Mr. Rana's storage of the firearm was not proven to be careless, his words to the 911 operator were most certainly careless, setting off this litigation, which was completely avoidable. However, it's sort of implying there that his words were an offense. They might be under public mischief, but he wasn't charged with that. So, but, I mean, his words to the 911 operator were stupid. That's sort of the long and short of that one. The result in this case does not mean I have adjudicated on the issue of whether Mr. Rana should or should not be permitted to possess and store restricted firearms. That is a separate issue and one the Chief Firearms Officer may or may not choose to pursue. To be clear, this ruling did not require me to address that issue. Of course, right after this ruling, he's going to be going on to sentencing, and I don't know what the sentencing result is. Maybe I'll hold off on posting this just so that I can follow up perhaps tomorrow and see if I can get a hold of the Ontario court and find out if he's got a sentencing. Maybe find out if he's got an appeal. So there might be an addendum to this when it gets posted. But he is certainly going to be required to consider whether Mr. Rana should get a firearm prohibition. That's just part of the sentencing process on this. In parting, I would be remiss if I did not repeat and stress my earlier comments that despite the protracted litigation, both parties acted civilly and professionally. I would like to commend their conduct, and in particular, the conduct of Crown Counsel Mr. Black, who upheld the finest traditions of the Crown Attorney's Office in discharging his duties to the court and the administration of justice. So the other thing I should point out is that this result is going to, pretty much by necessity, Mr. Rana is going to lose this Beretta. So if, by virtue of him having been convicted, he's going to lose that gun. And so there is some consideration about that as well. Anyway, I'm going to sort of stop here. I'll try to include an addendum tomorrow if I can find out some additional information. If it just goes to thank you for watching, then you know that I couldn't find out anything. Anyway, cheers. So I was able to get some follow-up information here. Mr. Rana has been sentenced. He was sentenced to an absolute discharge, which is the lowest sentence available in Canadian law. Essentially what happens is the court finds you guilty, and then instead of convicting you, they enter a discharge, which can be conditional, which means that it comes with a sort of period in which it runs. You have conditions that you have to abide by, or in this case, absolute, which means that the court says, you did it, but off you go. So Mr. Rana won't have a criminal record. I know I made some comments about the, concerns that he'd get a criminal record. The judge has ultimately decided that he won't get a criminal record. And the only thing he'll suffer as a result of this is that the firearm is going to be offense-related property and it's going to be forfeit to the Crown. So he's going to lose the Beretta. And now I also called the Court of Appeal. Court of Appeal says that they don't have an appeal on the docket. So I suspect that he's already passed his appeal deadline. It looks like he's not appealed it. This is not surprising if the ultimate result is an absolute discharge, because who's going to go through the time and effort and the expense of appealing it if the punishment is off you go, no criminal record? However, that means that this decision stands unappealed, which is unsatisfying to me as a lawyer, because I really wish this decision had gotten appealed. There's a lot of angles that I would love to have seen addressed, but they're just not going to be addressed. So I hope follow-up courts don't sort of pick up this case and assign it weight, because it really, to my mind, is a case that shouldn't be given a lot of credence, because it's full of problems. It's one that I think should be largely rejected by follow-up courts if they're asked to rely on this as precedent. But there's always the risk that they will pick this up and run with it. So, as I said, I'm not happy with that outcome, but I am happy that Mr. Rana is not being punished, because he's an individual who called 911 looking for help. What he got was not really great help. He got charged with this offense that's going to have been a tremendous stress on his life. There's some indication that it may have been a stress on his marriage. So I'm happy for the outcome for Mr. Rana. I'm unhappy for the outcome for the rest of us, but that's kind of the way law works. We'll have to see. This is a case I'm going to be sort of monitoring to see if other decisions start to cite it, because that is a worry for me. Anyway, thank you for watching. I know this has been a bit of an epic quest, but I do appreciate it. Please like this video. Please share it with your friends. Please subscribe to see more content. As I said, I'm going to be trying to do a mix of sort of shorter videos as well as some longer ones. And I also want to thank my Patreon supporters at the $50 level. D. Mo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt. And at the $10 level, my buddy Keith, Process Eng, General Counsel of the CCFR, John Robinson, TR, Roy Haddock, Freckles-Dack, Jean-Alexandre Tessier, Sir Goat, Sights and Arms Limited, Chaba Hollow, Craig Kwan, Akin Coxall, North Central Process Service, Toys Are for Boys, Ian Vaughn, Milan Vrekic, Terrence Griffiths, Doug Thompson, Mark D., Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Michelle Stotzel, Scott Sweetman, Mike Rhodes, DF, Stacey Cartmel, Tactical Advantage TV Canada, Ian S., Dave Leslie, Juan, Stefan Conquest, Darren Duell, Sean Crane, Pete H., Ian Hutchinson, Travis, BC Bushcraft Leather, John Singarty, Misako Marivich, All Systems Go, Ian Hedgedanek, Hello from Venezuela, Taylor Delnea, Rod Guzman, Matthew Nesbitt, James Cox, Zip Ties and Bias Plies. You should check out his channel. It's hilarious. Daniel Kang, Jean-Guy Toussaint, Richard, Brock Watts, Frog Clan Copper, who I owe a response to, Annika Bain, Tim McGill, Jordan Delaney, Rob Butts, Chris Joseph, Grant Farquhar, Malcolm Yogi, Andrew Elsich, Roberto Selbach, Dimako, and Texan Diesel. Thank you once again for watching. I hope I've armed you with knowledge. This case is a bit of a wild ride, so yeah, I just wanted to share it with you. I hope you've enjoyed hearing about it as well. Thank you once again. See you next time.